So he punched my car.
Holy shit.
I had a car parked. Yeah.
That's insane.
I know. I was like, what the heck just happened? I got so mad.
Oh my god.
Good morning, Kayla.
Thanks for freaking out.
I know.
Our sushi was great.
It was really good.
Snake head.
Snake
so much.
It was yummy. Jay and I kept eating more.
Yeah.
Good morning,
Good
Kayla.
morning.
Long time no see.
I know, right?
Oh, shoot. Hold on. Let me get some.
Turn the speakers up down
Oh,
there.
yeah.
From the computer.
Can you do, okay, just a second. We gotta get some sound going.
You're struggling.
Oh, let's see here. Can you hear us?
I can hear you.
Shit.
Oh, just barely.
Can you talk again? We can barely hear you.
Oh, hello. How are you?
Not working.
Good morning.
Oh,
Wait,
there.
that's getting better, Julian.
Oh, we're getting there. Slowly but surely.
Now I got you.
How are you?
Good. How are you guys?
Good. Are you still on the East Coast, or are you in Oak Harbor now?
East Coast for less than 2 weeks, and then I'm all yours.
You find a house?
Yes.
You did. Where are you moving?
So it's not really a house, it's more like land, but that's okay. So I will be living in Oak Harbor on some land, and I will build a house within about a year.
That's exciting. Who's building it for you?
Great question. I will know that when I meet with a series of builders that I've lined up.
Good luck.
Yes, lots of fun.
Too funny. Well, that's exciting. Well, welcome back to Oak Harbor. So it'll be nice to see your face occasionally.
I know, right? I'll be able to actually be in the office, visit, bring treats, maybe do this in person.
That would be incredible. Absolutely incredible. So awesome. Well, where do you want to start, Kayla? Do you want a screen share? Do you want some control over this? Let's see here.
Yeah, let's do some screen share.
I'd love to hear everybody's spiel on how do you sell a title report in a minute or under? What is it? Julian, I'm going to start with you. What's a title report?
A title report's going to show any sort of liens, outstanding, any sort of outstanding issues with the property that come with the property that don't make it free and marketable to transfer over upon purchase. And so this will kind of tell you in there that they will need to address while under the contract to obtain the.
Everything that comes with the lay of the land. That's basically what it is.
You said it a lot simpler than that.
Yeah.
Kayla, 1 minute under. What's a title report?
Title report tells you the nuts and bolts of a property, good, bad, and the ugly.
I love that. There you go. Simple version right there.
That's great. So can everybody see my screen?
Yep.
Wonderful. Okay, so this is a property that we have done. This is a property that the Kelly Lane team has closed.
That was a nightmare, a little bit.
So this one here is pretty basic in terms, obviously you have the front cover sheet that just says, hey, this is a title report. Page number 2 says who the underwriter is. We particularly are underwritten by 3 different people. So Natick is one, Stewart is another, and First American is another. Any title company you go to, whoever they are underwritten by is whoever you would end up filing a claim if you ever needed to. So it wouldn't necessarily be with Premier Title or Land Title or Chicago Title. It would be with the underwriter.
Kayla, so how many times during your career have you seen somebody file a claim and actually win on that claim?
Once, and it wasn't with us. So we had to help them actually fight the title company is what we ended up doing.
And so what was it over and why did they win?
So this particular case was because the title company that closed this property, it was a condo. The owner at the time owned two condos side by side, or 2 units in the condo side by side. What they did is the agent wrote up the contract with the correct property address, but the incorrect parcel number. but or the correct personal, but the incorrect legal. So that's what it was. So what ended up happening is the title company basically sold the wrong unit. And they went through, processed all the paperwork, signed everything, sold the wrong unit. So needless to say, 2 years later, when they showed up at our door and was like, hey, we're selling our property, they don't own it. So that became a nightmare. On top of all of that, when they paid off the liens against this property, that particular seller knew that this had taken place, and they actually quit claimed that property to a girlfriend. So to make matters worse, that happened. He quit claim to a girlfriend, even though he had debt on the property. So then this title company, because the address was right and the legal was right and they didn't do their due diligence, had to pay out their lien and basically go after that seller for the difference.
Oh my God. Okay, so that brings up a really good point. So where you're at right now, as a buyer's agent, and when you're writing a contract, don't you recommend that you're questioning the legal description, because sometimes they are wrong. Shouldn't you go back to title and say, hey, look, something looks weird. Can you make sure this is the right property? 2, checking the parcel number. 3, balancing it against the assessor site. 4, checking to make sure the address is right. I mean, I know all this stuff seems kind of simple, but really not simple. You know what I mean?
Well, we just had one that did this too, where we had that exact issue where the address was accurate, the legal was not accurate, and the parcel number was accurate. So what we did is we had them go backwards and reinitial the accurate legal. So, which we brought to the agent's attention. So then they just reinitialed it and attached it to the purchase sale agreement.
I mean, I have been in the middle of the contract. Somebody forgot to add a parcel number. Somebody forgot to have 2 legal descriptions, and there was several pieces to the property. You guys, and it's okay. You want to catch it while you're in the middle of it and go, hey, listing agent, I think we've got something wrong, and then you fix it. When you don't want to catch it is after everything closes. So, I mean, we were supposed to practice good faith in the law of agency, and this is part of doing good faith due diligence for your clients, because they don't know what the legal says. So I don't think it hurts sometimes if you're questioning anything to go back to the experts, go back to title and just say, hey, can you take a look at this and make sure the P number, the address, and the legal all match? And it is what you're buying. I mean, it doesn't hurt you guys.
That's the most important thing.
Yeah, what are you buying? I mean, that's, do you know what you're buying?
Right, and that's a big thing. In this particular case, I mean, with that other loss, he owned both lots. So in that particular case, it's not like you'd go onto the county website and realize, hey, this isn't my seller, which would be your first trigger point. It's the same seller, same relative address. The only difference is just a number, which is the lot number. So you got to be very careful with the transposition of numbers or things in that case, or you could end up ultimately being pulled into a lawsuit like this agent unfortunately was.
What's really hard, Kayla, is I had one of my first sales that I ever sold 11 years ago by Paul Nowell. The guy called me 2 years ago, and he said to me, he goes, Kelly, my neighbor just did a survey, and the shed it was like a carport that was built into the ground. It was on his, I mean, this was 10 years ago, you guys. You still get shit like this. I don't care how long you've been in, you're going to get people that call you. And he goes, I didn't know that this was encroaching on the other person's property. The only way he found out was because the neighbor did a survey. So the first thing I do is I'm like, well, let's call title and escrow. But there was nothing that you guys would do because of the fact that it wasn't surveyed while we were purchasing the property. So what have you seen in circumstances like that with title? Have you seen that it doesn't get awarded? There's no recourse on that when there's, structures or things that are going over the property and they're not determined during the course of the contract.
So in terms of title, for a claim, there's specific types of title insurance that you can get, of which you would be granted. So for example, a homeowners plus policy includes the requirement of a survey. Right, so you'd have to get that survey.
Nobody does that, Kayla.
No, nobody does that. So then if you don't get that, then no, that particular process would not acquire, it wouldn't apply for a title. But what you could do is go to a title company to get it rectified, which we've done several times to help people, because title is like a foreign language to most of the population. So what you would do is you would do a boundary line adjustment. They'd give you a few feet on this side, you'd give them a few feet on your other side, and you'd call it a day. So yeah. It's kind of a pain in the butt, but that's really your solution. Or you remove the structure, but nobody wants to remove the structure. So these are your options.
5 minutes after it recorded, and I was no longer the legal owner.
No.
Grandma's piece of property too. That's what was so crazy about it. Our septic was on part of her property. Well, and then it was the new buyer, brand new first-time home buyer.
Oh,
Well,
no.
I will help you out. Don't worry, I'll get it all rectified. So Patty, luckily we did swap some property, did a BLA. Steve actually helped me with it, and then I had to do a reappraisal for the bank because they were freaking out, of course, but it was the same dirt for dirt. But it didn't happen, you guys. I mean, shit like that happens, and it's not fun. I'll tell you what. Right when you hang up and somebody calls you and says, "Hey, we got a freaking problem." Oh yeah, we have a problem. You know. So, but I think also using good judgment when you're out at the property, if you look like something looks like it might be encroaching, it's a good time to talk about it. You know, like, hey, I mean, you don't know where the lines are exactly, but I'd be having that conversation with the listing agent, with the sellers, and trying to figure out if something is encroaching on the property.
Yeah, and encroachment's a big deal, especially if you have a lender involved, because that lender has to approve everything. You can't just record a boundary line adjustment and call it a day. That lender has to approve, re-record, because they technically have a lien against the property. So you can't do all of that fun stuff without their permission, which just lengthens everything.
It's fun, you guys.
Oh, anyway, in terms of title, so this particular underwriter is Natick. Basically, when you go to title, there's several things that you're going to look at. Your number one thing you're going to look at is this page here. Everything prior to that is boilerplate. This is going to tell you the nuts and bolts of your actual transaction. You're going to want to make sure that your sales price is accurate. This is the type of policy. A standard or a homeowner's is standard. Standard is the cheapest. Homeowners is what's written into your purchase and sale agreement. So that is the standardized version of a homeowner's policy that you guys offer. You can go cheaper and manually write in a standard.
Okay, can we stop for just a second here? You guys, for the new agents, it's on the 22D, and it's in the purchase and sale agreement that you get an Alta middle of the road property. You don't want to check any of the other box because it's less than or more than what's being offered. So it's always Alta. I mean, I don't know, in any circumstances, why would you want to do less than an Alta, Kayla?
So there's some circumstances where you don't qualify. So for example, vacant land with no address, you can't get those endorsements. So a standard is the only thing that would qualify for that. If it's just land with nothing on it, you can't get an Alta, which is why a standard policy is what would be offered. The adverse side of that is to get a homeowner's plus. If you have a multi-million-dollar property, they want to know where all four corners are. They want to know everything there is about it, which is the only time we really see that be used is a multi-million-dollar property. Then they get a survey, or a survey's already been done. They would qualify for this type of policy.
How many of those do you typically see issued?
In a year, we probably see 4 to 5.
Okay, and the circumstances are typically like big tracts of land, right?
Right, huge tracts of land, or somebody who just wants, they got stupid money to spend in reality.
Because those cost quite a bit more, right?
Yeah, substantially more money.
And what is the protection to the buyer with having a higher policy?
Basically anything and everything that would come into play. So encroachments, land use, if you've got tidelands or any of that stuff would all come into play in terms of this. Outstanding judgments, liens, loans, everything would come into play, including the four corners.
Oops.
Yeah.
Are we good?
I just see a picture of you, but that's okay.
I'm not sure what happened. Okay. All right. Did the video die?
Oh, I see you
there we
guys.
go.
again.
All right.
We're back.
No.
Quick meeting, we're good.
We're
All right, so this is your number one screen. In most cases, you're not going to care about what type of policy it is, because they're all going to be about 99.9% of the time, it's going to be a homeowner's. So in reality, you don't really care. The main thing you want to care about is make sure your sales price is accurate. Obviously, if you did a sales price adjustment, this should reflect that. If it doesn't, then we don't have it. Down here, this
Two
is
title
what was that?
I said there's two. I'm just sharing with the new ones. There's 2 title policies issued.
Yes.
One for the bank, one for the buyer.
Yep. If you have a lender, this right here is where that would go, which I have another title report that we can go over and I'll show you that. That one's completely basic and what you'll see on just about everything. So this one here is going to be your proposed insured. This is where you want your future buyer's information to go. So in this case, we've got the 2 names here, a married couple. It could be a single person. It could be a married person as their separate estate. There's a million ways to take title, but this is where their information is going to read. The number one thing that you're going to want to make sure in is that your seller is actually your seller. If this does not say your seller's name, you have a problem. Number one, verbatim, this is the issue. In this particular case, you'll see the heirs and devisees. This means you have a deceased person either in title, listed on title somewhere. In and of itself, it comes with problems. Deceased people in title or escrow is just a problem in general. There's something that will need to be done. So this here tells you we have somebody who's deceased. Hopefully this is your seller. If not, again, we have an issue. So this is where you want to start. After that, these are all your, this here is just boilerplate. That's just Steve's signature, who owns the company. This here is going to be your legal description. In this case, I'm showing you something more complicated where we have 3 separate parcels. So you have a parcel A, a parcel B, and a parcel C. So like Kelly was talking about earlier, you may want to take a look at this. Legal descriptions, especially if it's not a lot in a block, they kind of suck in terms of reading them. I mean, who's going to go walk this property and thence north 225 feet and thence east to, it's just not going to happen. So you just want to kind of look at it and make sure it relatively matches your photo of the property, your map. You're going to want to make sure that it looks relatively accurate. And this is where any boundary line issues would come into play. This is what we would do, is we'd have to look at a map, read it, and map it out verbatim based on the feet. So that's how we would have to do it in title. This section here is your Schedule B Part 1. This is standard for all of Island County. So this is not particular to your property. This is everything that could be in Island County. So this is 100% boilerplate. So you don't really care about this, basically. That also goes along top with your general exceptions. This is everything that you should know in Island County. When you actually start carrying is when you get to special exceptions. This is everything particular to this property. So we always start out with our excise tax. It gives you a breakout of what excise tax is. That is always going to be number 1. Number 2 will always be tax information. So in this case, we have 3 parcels. This shows the amount that's billed, the amount that's been paid, and the amount that's due for this parcel. Here's your property ID number and your assessed value. You want to make sure this is accurate. You want to make sure your parcels and your PID numbers match, that this is actually your property. This is also where things would come into play if it's in a classification. So if they're a senior citizen and they have that classification for a senior removal, if they're in an ag classification, if they're in a forestry classification, any reduction in taxes will be listed right here. And that's really important because if you are in a classification, you will need to apply for a removal or an exemption, which takes time. The county right now is processing a minimum of 15 days. So if you think about a 30-day or a 45-day purchase and sale agreement contract, 15 days of those, and this is business days, are already wrapped up just in the county review. So you need to know that information. The next thing we have here is any deeds of trust, outstanding loans, judgments, or liens against a person. So the seller in this case. Does everybody know what a deed of trust is?
Street designation.
I remember.
Oops, hold on. Kayla, I think we're having some issues. Can you hear us?
I can hear you guys, yeah.
Okay, cool. All right.
I just can't see you.
Does anybody have questions of what a deed of trust is?
Can you explain it?
Mackenzie said, can you explain what a deed of trust is?
Absolutely. So anytime you get a loan with any lender, whether you're borrowing money from a seller, your aunt, uncle, cousin, brother, or an actual mortgage company like Wells Fargo, you will get a deed of trust. So this deed of trust goes of record that says you owe money, how much money you owe, which in this case is $180,000 that you borrowed on September 2nd. It was recorded on September 16th and who you borrowed money from. So that's what this is. This is a lien or a cloud on title. So a deed of trust is always recorded when you borrow money from somebody and use your house as collateral.
Okay, so I want to pause for just a second. Kayla, just a second. So if I'm a buyer's agent and I'm looking at this and I start to see 1, 2, 3 deeds of trust and I start adding them up and I'm looking at the purchase and sale price and I'm going, shit, we have a problem. I'm not going to get paid.
Short
Right? I mean, that's, you got to look at that, you guys, and say, just do the common math. Because I have had that in the past where I'm like, we're off money. You know, when I pull it, I'm like, shit, this person's in trouble. Even in a good market. I had a guy that was like, I mean, I think I ended up pitching him $50 just to get the dang thing because it wasn't much, but it was one of those things of it's like, we knew that it was a short sale, just about a short sale. So you do want to check that to just kind of do simple math to make sure it makes sense. You know?
Right, absolutely. And dates matter too. So for example, this says 2020. So that means 180,000, you may be 10,000 in, I mean, maybe 170,000. But if this said like 1960s, you might have an issue with an old deed of trust that was paid off previously, but is still on title. So somebody didn't do something down the line that would also pose a problem. If this deed of trust is still of record for whatever reason, but they've paid it in full, it could be as simple as contacting that mortgage company to say, hey, you need to do a reconveyance, and they'll process a reconveyance and go that route. Or as we've seen in the past, that company has since been bought out by 3 other companies since, and nobody has a record of this. And so you've got to be creative and go through a whole avenue. Worst case scenario, you'd have to do a quiet title action to get rid of it. But that's not common. Most of the time you can find somebody who's willing to sign off on it. But these could be time consuming. These could be deal crushers. These could be 30, 60, 90 day out extensions. So that's definitely something you're going to want to know too, is how much, what do you have against this property? If you only have 1 loan, because why is the title report showing 3? Something of that nature could be an issue. From the deed of trust section, so this is everything that would be against this property. In this particular property, they only have 1 mortgage. There's no issues whatsoever. 1 mortgage for $180,000. They're selling it for $650,000. We should be just fine. That's all that's against this. If there was anything else, judgments, liens, a divorce case, that would be listed as number 5, 6, 7. Everything that costs money basically is number 4 and on. After the money comes everything against the property in terms of easements. So in this case, this is just your exceptions. This is for the state of Washington. This is easements. This is your water and electric easement, your reservations. Reservations are things like oil, mineral reservations, things of that nature that the actual owner of the property doesn't have. The right to make necessary slopes, cuts, blocks. Basically, you can do whatever you want to your property. Restrictions. So these are all standardized CC&Rs or easements. So if your people, for example, want chickens and they live in a subdivision and it says in here, pursuant to CC&Rs, you will definitely want to read through those CC&Rs that are attached. That'll tell you whether the people can have chickens. And that's where this will be, is in here.
Let's talk about this for a second too, because a lot of the places in Oak Harbor have CCNRs on title, but there's no HOA. How does that work?
So you don't have to have an HOA to have CCNRs. So CCNRs are just covenants and restrictions. Covenants and restrictions are either developed by the plat owner. So if you're in a subdivision, whoever built all the homes was the original plat owner, and he or she went through, created restrictions that they wanted that says, you have to remove your garbage. You can only paint your house certain colors. You can't have any parked cars in the front of your house. Things along this nature, but it doesn't require dues because you don't have a community land. It's maybe you're in town, so the town still pays for water and your electric and maintenance of roads. So there's nothing to pay for in that regard. There are obviously other HOAs that do require dues, that maybe you pay for a community, I don't know, maybe access to a beach. So you've got community access to a beach, or maybe you've got a pool, you know, a local community pool that you pay access to, or maybe you just have a park down the road that nobody maintains and it's been, you know, growing over weeds for 30 years, but somebody's still collecting payments. These are realities. And unless the group of community homeowners gets together to either amend, terminate, get rid of completely the CCNRs, those CCNRs are in fact current and till the end of time, until they're amended.
So, but how do they get enforced if there's no HOA and there's no money to enforce them?
So you basically have to have 1/3 of all of the homes within a certain subdivision. So if you can get 1/3 of the people to sign off and create, that is how you would create or amend CCNRs. So most of the time, what you see today, for example, is in a specific subdivision, the builder of the homes in that subdivision created these CCNRs originally that people should follow. Now, if you have nobody, so if you don't have like a board of directors for that homeowners association, who's going to enforce it? Nobody. So in reality, you may have CCNRs, but you don't have a board of directors to come knocking down your door to put a lien against your house because you painted it pink. It's just not going to happen. So in reality, you have CCNRs, but they're not always enforceable. So it's kind of a weird, tricky situation. However, if you do have dues, yeah, what's up?
Regularly see HOAs reenact. So let's say you've got a 1950s neighborhood in Oak Harbor, and their CCNRs recorded, and everybody started parking their boats and RVs and everything in there, even though the CCNR said you couldn't do it. I mean, I don't see that ever happening where it's like, hey, let's get the HOA back together. I mean, do you see that?
No,
now
not really. Yeah, so like Fireside, for example, has been without a HOA for I don't even know how many years at this point. They say they have an HOA, they say they have CCNRs, but the whole CCNRs, the board of directors, everybody just kind of crumbled and nobody keeps up with it. So no dues are assessed, no water is assessed, no nothing's assessed. But they do have CCNRs.
Right, and nobody's enforcing them.
They can't because there's nobody to enforce it. So usually you have to create a group, unless a whole bunch of homeowners got together and said, hey, we're going to go take down Charlie's house because this is unacceptable. And then they'd have to hire a lawyer, and then they'd have to go that route and reinstate somebody. It's just not going to happen.
Couldn't enforce it on another neighbor if there were like CCNRs that their neighbor was breaking. Like they couldn't.
Well, they have to sue. You know
yeah,
what I mean?
okay, that's what I thought.
So do you ever see that, Kayla, where the neighbor says, hey, you know, per the CCNRs, there's no active HOA, but you're parking your boat there and we don't want the boat there, it's ugly. And do you see the neighbor come up and say, well, I'm going to sue you because you're not following the CCNRs? I mean, do you ever see that?
I've actually only seen that one time, and it was two neighbors that were just in a dispute constantly. And it actually started with a shrub that was in the middle of both their, like they connected their properties. So there was a shrub that was overgrowing. The guy was anal about maintaining, you know, his shrubbery, and he could only maintain his half. So if you imagine, he's pruning this bush only on his side of the property. He was very upset that his neighbor wasn't pruning their side of the bush. So one was outgrowing and the other one looked pristine. So he actually came in, pulled all the CCNRs, reviewed them, hired an attorney to get this guy to cut his bush.
That's when you have more money than you know what to do with and you want to waste shit. I mean, that's what that comes down to.
Pretty much. And that's what ended up happening. The other guy was like, fine, let me just cut this. This is absolutely absurd. But that was, it was an HOA that was enacted, I don't even know how many years ago. So there was nobody to enforce. They didn't pay dues, but it did say you're supposed to well maintain your yard. And so that's what he went off of. He hired an attorney and the attorney served him and he was like, this just isn't worth it. So
I mean, I hate to say this, Kayla, but this is how I judge it with my clients. If it's a shit ass neighborhood and you can tell that a lot of people don't have a lot of money, they're not gonna have money to sue people, okay? You go into the higher end neighborhoods and they're dissolved HOAs and they're multi-million-dollar houses, yeah, they may have some money to go after your ass if the HOA is not active in their CCNRs. That's the way I evaluate risk, knowing that, whether people have money to sue or not sue. I mean, the odds, I'd say, are extremely slim. Extremely slim. But it's
I've only had one, so yes.
You want to be treated, right? Like, let me give you an example. So I had one of my neighbors, which I couldn't believe he did this. He's like, hey, you're a local real estate agent. Would you review this addendum? We want to make this change to the CCNRs. He walks down, he sends me. He didn't even walk down. He mailed me the addendum, which was for my fucking property that he wanted to put regulations, stipulations that my trees were mandated to be cut at a certain height after the fact that they approved my trees to go in there. I nicely called him back and I said, I don't think that you're using me as an example to try to amend CCNRs and put restrictions on my property for things that you guys have already approved. I don't appreciate that. I said, I'm more neighborly. If you want me to trim my trees to protect the views, I'm totally fine doing that because I respect that because it's due on a neighbor. So I walked up to the neighbor that my trees affected and I told him, I knocked on his door, I said, hey, I just want to let you know if my trees are ever blocking your view, I'm totally fine with chopping them. I said, that's just the way I work on a handshake, but that's not the way every neighborhood works, But I always say do unto others the way you want to be treated in the sense of living in neighborhoods, not that that's always the case, and that's kind of an old school mentality. But again, I didn't want to record that onto my property because then it was a stipulation that would cause a restriction that maybe another buyer wouldn't want, So.
Absolutely. Well, and it becomes a gray area. So HOAs and CCNRs are tricky in and of itself. I mean, you've got a group of people, you've got newer developments that go in, about 99.9% of the time will have some version of CCNRs. They will. And unless those CCNRs are then taken over and adapted by the homeowners itself, the likelihood that they become an actual, enforceable issue is pretty slim. Most homeowners, and this is most, definitely not all, don't like anybody telling them what to do when it comes to their property. They just don't. There are definitely the opposite side of that where CCNRs can be beneficial. I mean, if you have a nice house and your neighbor has 30 junker cars in the front of their property, that diminishes your value. So some people do like certain aspects of CCNRs, which is a group in a common mutual fashion between all of the neighbors to not have a bunch of junker cars. I want my property value to still remain high. So they're not all bad. What was that?
I have another question. So
Yeah.
What are the odds of people unrecording stuff on CCNRs when there's groups? Do you see that a lot? Like I'm recording easements, I'm recording certain things that are on the title when you've got groups of people. Isn't that extremely hard to do?
It is, because you'll have to get a total group of people to sign off on it. So aside from having to get an attorney to draft it, you have to get a whole bunch of people to then agree and sign off on the new terms.
Right, because one of the things that I've seen, Kayla, too, is that VA lending in Oak Harbor, if you get in rural areas and then let's say there's 10 houses down this rickety little road that has potholes and it's all the day long in Oak Harbor, and now all of a sudden you look on title and you don't see a road maintenance agreement. Who maintains the road? And the problem I've had in the past is you have a VA buyer that wants to buy them there. Well, all of a sudden the lender calls out on there, where the hell's the road maintenance agreement? You can't on that property because it's a VA stipulation unless you have a road maintenance agreement. What are your odds that you're going to knock on every freaking door and get them to sign up on this road maintenance agreement? Have you seen that before?
We have. We've actually had to do a few of them. So in the 12 years I've been doing this now, I've probably seen 3. Typically with like road maintenance agreements, you don't have too many people that are on that road if it doesn't already exist. I mean, it's just not very common, but it is common enough that you don't have them. And that's exactly the solution. You have to have somebody draft a road maintenance agreement, go knock on everybody's door and explain it. But at the same time, you're asking people to sign up to pave eventually or gravel or take care of this road, which costs money.
Yeah, I think the hard thing with that, Kayla, too, is that you don't know which lenders are going to call that stuff out or not. You know what I mean?
Right. Yeah.
Because they have 2 different VA lenders here. One's going to call it out, and the other one doesn't care. Right? It depends on how hard they scrub the file. And the hard thing about that, too, is you really can't get a head start because you don't want to raise a red flag with a lender on it. You want to let them just do their thing. But if they call it out, then, yeah, there could be a lot of door knocking that you may have to do to get that agreed upon. But
and definitely reach out to title before you jump through it, because sometimes title can find things like in the CC&Rs originally done that is minuscule and it's not titled a road maintenance agreement, but maybe you can find a clause in there that says all homeowners must agree to maintain the road. And as simple as that, some lenders will take it, but others on the other case want their own formal actual states titled road maintenance agreement and are a little bit more stringent about that. But sometimes you can kind of get a workaround with some verbiage that's already classified in the CC&Rs that already exist.
See, I love that, you guys. This is why you use your professionals to help you solve problems. So the second you get stuck in a rut with a lender and a requirement, so I'd be like, Kayla, help me out. What have you seen in the past? Because when you get years of experience behind you, there's workarounds, right? There's always workarounds. So you don't let it die at that. You try to resolve it in another way. So
thinking outside the box is great. So when you find the right person that can think outside the box, that's the person you need to keep on your team, because especially in this industry, there are so many doors that's shut that you just got to find another one that's open. There's a million ways to do this job. There's a million different ways to get it to the closing table. You just need to find the right one for that client in that particular avenue. So in terms of the commitment, this is basically where you would find anything that's against your sellers would be in this section. This is your section here. It is called the B1, or excuse me, the B2 in this case, the special exceptions. This is where anything that would be against your sellers or this property, your CC&Rs, your easements, your road maintenance agreement would be listed here. As you continue down, you get to the notes section. Notes are just things that you may want to know, but don't necessarily have to be followed or may just be for your information. Notes are also where you would find anything against your buyer. So if you have a buyer that has a judgment, it's going to show up in notes because it's not against the property yet. But if your buyer has a judgment or a lien against them in any way, and they have a lender, that will have to be paid at closing or before. They will not be allowed to purchase this property without that being cleared.
So child support. If the hubby or spouse is behind on child support, and trust me, that sometimes they paid it and there's no record yet from the government, and then
exactly what happened.
I've had it too, and it's a pain in the ass because you have to go back to child support services, get the documentation and send it back in, and it can take forever. I've had it too. And the guy I was working with, he's like, I paid it, Kelly. I paid my child support, but we didn't have record from, and so we couldn't close. So, and that's a buyer then, because it's like they can't close and the seller wants to close. So when you see stuff like that, this is why you look at title reports, because it's like, ding, 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 I gotta help. You know, I gotta figure out what I need to do to help. I mean, obviously Kayla and them does it too, but you're calling your client too. Say, hey, is this true? You know. The other thing too, Kayla, is sometimes wrong people get pulled on title reports, correct? Like if it's a common name like Bill Smith or whatever.
Yes. So those are judgments. Judgments do not give full information. So when they record a judgment, it'll say Jane Smith, but that's basically it. Doesn't give an address. It just says Oak Harbor somewhere, or Anacortes, or Skagit County, or whatever county. And that is where it's recorded. And that literally is all it says. Well, there's a million Jane Smiths in Island County or Skagit County. So what would happen most of the time, so my title people try and be diligent enough to either reach out for what's called an identity affidavit, where the client would have to fill out their name, their social, their birthday, and then we fax that over to whoever filed the judgment to say, is this the same person? Is this the person you're looking for, basically? And they'll either respond with yes, so then it'll go on title, or no. But we try to do that before we actually put it all on title, or maybe you call the person and they're like, yep, that is my lien. Or no, that's definitely not, and then you get the information after the fact. So we definitely try and do that before, but if we can't, or we can't get a hold of the people, or we can't get a hold of the agent, then yes, it will show on title, but it may not be yours. So you'll have to do that due diligence to either prove that it's not, or get the information if it is. So for example, I have one right now that just showed up, and it's from 2012, and it's the buyer, and they have a judgment. So the lender said, nope, that's not theirs. The buyer in turn called and said, yeah, but that went away with my bankruptcy, which PS, bankruptcies do not remove all judgments and liens. That is a common misconception. Just because you file bankruptcy does not mean everything goes away. In some cases, it does. In some cases, it doesn't. Depends on the type of bankruptcy, depends on everything that you're doing. There's a million factors to that. But just because somebody says, yeah, that went away, I filed bankruptcy, that's a false statement.
So another question, I get this a lot, especially in a military town, is there's two people even married. So you write it, only one qualifies for the loan, Kayla, because one has good credit. But they're married and one wants to be on after. So give me a scenario like that. How do you put the spouse on after even though they don't have good credit?
So you can own the property without being on the loan. And you can also be on the loan without owning the property. So there's a million ways to do it. Now with a VA loan, if you are not married, but you live together, which is kind of a common thing that we're getting now, is where you get boyfriend and girlfriends who've been together forever. They want to buy a property together. If you are in a VA loan, that circumstance does not qualify. You cannot get a VA loan with a significant other, get the same loan with them, and purchase the property. They will not be allowed to be on the property. That's really your one and only circumstance where they can't be. But if you have a conventional loan or any other type of loan, you can both be on title and only one person's on the loan. We run into that all the time.
Well, what if they're both military?
But one qualifies and one doesn't. Is that what you're saying?
You're saying if they don't qualify, but if they're not married and they're both in the Navy and they want to get a house together, they can do that, right?
It'll depend on the lender. Most of the time, because the reason for this is because you have to use your VA. So you have to use your, whatever it is, DD42 or whatever that thing is. So you have to use your VA eligibility. So if you're not using both VA eligibilities, it will only allow you to use one. And if you're not legally married, they will not allow, it's part of the VA guidelines. They can't allow you to be on the loan or on the house because you're giving basically, it's a VA backed loan. So if somebody who's not VA eligible, or in this case, married to the veteran, which then you would have community property interest, they'll have a tough time repossessing, which because it's a VA backed loan, they will not guarantee that. So it's a VA guideline and a VA rule that they will not allow that.
So can someone be added later on to the loan? Like say that like this two people.
No, without a refinance.
Okay.
Put somebody back on.
Okay.
So yeah, technically speaking, you could do a quick claim deed.
But why would you want to if that changes the terms? Let's say your rates are higher. You wouldn't want to add them on.
It just
and then you got to pay all the fees.
Yeah.
You're 2%. I wouldn't do it.
Yeah.
So give a scenario when you would want, when you could quit claim a spouse or girlfriend onto title.
So you can technically quit claim anytime you want. However, that is a breach of contract, and the contract being your deed of trust. So when you sign, because you're purchasing a piece of property and you sign that deed of trust, if you read all 13 pages of that deed of trust, there is a clause in there that says if title ever changes without the notification and express sign off from your lender, they could immediately call that loan due in full.
But will they, Kayla?
Will they? No. who's got the time to go and research title or knock on your door and say, hey, do you really own this property? No. I mean, in reality, no. Nobody's got the time to stalk the recordings and that kind of stuff. But
So
in reality, could they? Yeah, absolutely. It's just like
Right.
a reverse mortgage. In a reverse mortgage, for example, if you move out of the house for any reason, they can call your note due in full. The difference is with reverse mortgages is they actually do that.
Who was on that?
but a lot of them, like, it's so crazy when you have multiple LLCs and there's multiple entities to that LLC. That's why you always want to ask your client how they take title. And if they don't know yet, you want to do and or signs behind it so you can assign it after the fact. I mean, during the contract. But yeah, most banks have and this guarantor, and I mean, they go after every entity they can when there's corporations like that. They want everybody to guarantee. So, cool. Let's see. What else do we have?
So what would be the motivation for a bank to call it due when you quit claim someone?
I don't know. I mean, they want their money.
Yeah, it's a policy that you can't change the title status in any way.
Yeah, the reason they do that is because they'd have a tough time foreclosing because that person didn't borrow the money. So, for example, if you've got a Jane Doe who owns a property and borrows the money from the bank, and then she quit claims it to her and John Doe, when they go to the courts to foreclose, John Doe owns 50% of this property, but he did not sign any documentation stating he owns the bank money. So they have to go through a million different legal disclosures, and it takes them 6 times longer to foreclose because somebody else owns half the property. What's that? Yeah.
Oh, there we go. Now you can hear us.
Kayla?
Hey, I'm there. Are you there?
Back. Sorry. Technology's crapping out on us.
No, I probably.
Me too.
All right.
All right. Any other topics you want to cover for the next 10 minutes?
That's up to you guys. What other basic questions you guys got? I mean, in this particular case, the only thing that's listed in the notes section on this one is just who's authorized to legally sign on behalf of this deceased person. So you're definitely going to make sure that that matches whoever you guys have as a contact. We've had that in the past where, you know, somebody has passed away and everybody thinks that their child gets to sign off, and so they have them sign the full purchase and sale agreement. It goes all the way to title. Well, come to find out, they actually went through probate and there is a personal representative that's not that person. So you run into issues like that, which is fairly common because a lot of people don't understand that you either have to go through probate or have lack of probates or things of that nature. There's a million things you got to do when you have somebody who's deceased or when you have a trust or an entity in title. If you ever have a trust or an entity, you'll have to provide documentations like a trust agreement or an operating agreement, things of that nature, to prove who is authorized to sign on behalf of that entity. So when you have sellers, it's really important to find out exactly how they take title. So look at your title report if you got preliminary title or just the previous deed if you only got a listing package, to make sure that whoever is signing your purchase and sale agreement does legally own the property or at least has legal rights to sign on behalf of that entity.
That's why it's always really important to ask, you know, how they're writing the offer. Are you married? I know it seems invasive, but you have to ask those questions.
Mhm.
You know, there's going to be 3 signers on a purchase and sale. I mean, I sometimes have 5. It's so annoying, you know, but there's who's on title, how many people are signing. I mean, you may get multiple people buying the property together. I mean, just making sure you know who's buying. Somebody's leaving, you need a power of attorney. You know, planning for prior to closing to make sure you've got all your steps taken care of. When you need power of attorneys, when somebody's like, hey, spouse is deploying, wife's in town, Kayla, I'll have them swing by. You need to make sure that they sign before they take off, you know, all that stuff to get that power of attorney. So you don't want to like miss those steps partway through the process and not have people available to sign or the legal documents that you need. So, let's see. Did we lose you again?
Oh, I'm here. I'm just listening.
What other stories do you want to tell us? Give us one more story for 5 minutes. A horror story.
So I am doing one now, which is a pain in the butt. So the people that own it, it started out with a trust. One of the trustees had passed away. So his brother decided to do basically a successor trustee between his sister and his sister's husband. So then there's 3 trustees now. The problem is that his sister's husband went into a bunch of gambling debt and he owned 1/3 of the property. So 1/3 of this property was actually repossessed by the lien holder, who happened to be an individual, not a major company, an individual of a corporation, mind you. So that corporation took over his interest. So we have on our title report about a good paragraph as to who the vested interest is, because you have the full trust name, successor trustee, which is a separate entity or a separate trust split into 2 different sections. And then you've got this 3rd entity that actually repossessed and also has a lien. So if you guys didn't get title on this, for example, prior to selling it, because you'd only think there was 2 people that own this property, when in reality an entire separate entity has to sign off on this sale, you'd have a big issue. And in fact, this has been going on for about 1.5 years now, where we're still waiting for the attorneys of that entity to review, because they're entitled to 1/3 of the total proceeds. So,
okay, so let's talk about another scenario. I know one story always leads me to another story. I like spouses that got divorced, and one signing off on the deed because they want money, more money. So
yeah.
What are some scenarios like that? You know, because if it's been awarded in a final divorce, then they don't have rights to it. I've also seen it. I had a heroin addict that was married. They basically, because what's required to be signed off, because I want to say that she signed off on her interest. He said he had the legal rights to sell, then come down to the last minute because it was community property and they were still legally married. She had to come in and sign. The only way that he could get her to come in and sign, they were both on heroin, was to give her some money. It was horrible.
Yes, basically. So there's only 3 ways to transfer title, and that's death, deed, or decree. So in Washington State, you can only do the 3 Ds. So if somebody dies, that will transfer title. If you have a decree, which is a divorce decree signed off by a judge awarding title, or a deed, which would be either a quitclaim deed or a warranty deed or bargain sale deed, any type of deed transferring ownership for whatever reason. So for example, right now I have a divorce case where they divorced amicably, but in that divorce case, it says he owes his previous wife, his ex-wife, $43,000 to sell the property. Basically, he has to sell the property or he has to do a refinance and pay her $43,000. Well, right now he's selling the property. The problem is he doesn't have $43,000 in equity to give her. So that means he either has to come up with cash out of his pocket to pay for her, along with in the sale, because I can't legally give him the money and hope that he pays her, because I have a decree stating that he has to pay her. Or he can't sell the property and he's going to have to refinance for more money than what it's worth and then turn around and do a short sale. So divorces are ugly. Also, the other thing that it's a common misconception, if you have a sale going and you've got two people that are either talking about divorce or maybe they've started the proceedings, if those people are amicable and both agree, we can still close. So if both of them will sign off and say, yep, 50% each or whatever percentage, or honey, you can have it all, I don't care. As long as they both sign and are amicable, we are fine. If they disagree, this transaction cannot close until you have a signed divorce decree by, a judge that says who gets the property, who gets how much money, or how they deem to split it. So you can't do that. Yeah.
I've had where they both have attorneys and it gets held in the attorney's trust. So it goes to the attorney's trust, then they determine how they're going to deviate outside of the closing. So it all goes to fruition. That's another option you have. I know I have one right now that I have on the market right now, and the husband's basically got an attorney and told the wife they're divorced. She was awarded the property and was now told that she can't take the kids out of state. So I'm waiting to hear how it all pans out, because technically I'm not going to be able to sell her house if a judge says she can't take the kids out of state too. So there's as soon as you hear divorce, you better freaking dig deeper, because there's so much that goes on.
Yeah, it's pretty terrible. But even at that judge, so I had one where both people didn't agree, and then you have both attorneys that want the funds to be held in their trust account, so they can't even agree on which trust account to put it in. So then you can't sell the property. So if you can't come to any sort of agreement, I can't legally be a mediator. So I have to go off of what you guys tell me. I'm a completely neutral third party. I don't represent anybody. So I can't say, well, Susan said this and Johnny said this, and go back. I can't do that legally. So if they can't even come to an agreement, which I had, where they didn't even, the lawyers were fighting over whose trust account the money sits in. That's how ridiculous this got. Then we couldn't close until somebody comes to some sort of agreement, which we see all the time.
So when you read the contract for it to be held in the attorney's trust fund,
you don't. This is just on a
okay.
You get worried about it. Let's say you've got a couple that says, or a guy that comes to you and says, I want to write, or a woman, it doesn't matter. I want to write on an offer, but I'm going through a divorce. Well, they're not going to be able to get a loan. Yeah. Odds are, unless she's agreeable to it as well. Yeah. But then I'm involved with the lender at that point saying, hey, is this going to work? Because I do get some where they're going through a divorce and the wife will sign off.
Yeah, that happened to me in one.
But if they're going through a divorce and it's not pretty, and it's not, if the divorce is not settled, then usually they're not going to qualify, because the bank doesn't know how much their income really is, what their assets really are, because whose are they? I don't know, right?
Right, so, they'd have to be 100% separated, which we've seen, and then the wife or the husband in that case would have to do a quitclaim deed at the time of close, in order to relinquish any and all interest in that property. But
you worry about
this before,
like where I've had it too, where she's holding him hostage. Like, I'm not going to that document. Well, I had to do several extensions on it. Well, the buyer's agent's then calling me like, what's going on? I'm like, hey, the ex-wife won't sign off. I'm trying. We're trying. The attorney's involved. That's where you get worried, because she could hold it hostage and it doesn't close. That's a big deal. So on the buy side, your buyer's thinking they're buying a house, thinking they're closing, and the ex-wife's not signing off. So
Scott's done like 4 or 5 of those for me, and he'll do the whole process as long as they know that they're going to be like final divorce at closing.
Scott did that for me too.
That's good to know.
It's scary, but
it is scary. Because you're saying that everything is the divorce is going to be finalized.
You gotta feel it out.
But sometimes, it just depends. You either have a wicked couple that won't finalize, and they hate each other, and they're doing everything to not finalize, or you have like, just get me the hell out of here. Where do I sign? Let's get this finished. I don't ever want to see you again.
If they're going to get money, they're like,
let's wrap it up. So. Cool. All right. Anything else you wanted to cover? I think we hit our time allotment.
I think we hit it pretty good. But if anybody has any questions or needs, just to run a scenario by me, feel free and shoot me an email. Let me know if you think of something later, like, hey, what would happen in this case scenario? No big deal. Give me a call, shoot me an email. I'm more than happy to go over